Okay, I'm going to restate that because now we're recording. We are in a training session. This is not about live people. We're going to go over the purchase and sale agreement changes, Form 41C. We're going to go over 22B and 22D. I will tell you that when I took the 22B 3-hour course with Annie Fitzsimmons, she went over 22B for 3 hours. So that's how intense 22B, and people don't understand it. Is it a very important form that if you don't know how to use it, please reach out to me. I'm more than happy to help because it is a form that is very viable for our clients today. I actually have a friend who is purchasing a property in Eastern Washington, and their broker over there didn't even know that what 22B, what a 1031 exchange was, and how come there's no financing addendum. So I had to walk them through it to help her understand. And she was very thankful. And then, of course, my friend wanted to actually do a weird thing and do some cross-offs. And I said, well, that's practicing law and that can get you in trouble. And so the other broker slapped my friend's hand virtually, which was kind of funny. So, okay, I'm still admitting people. People are joining a little late. Remember, this starts at 2 p.m., everybody. I'm going to go ahead and start by sharing my screen. I might have to redo this because nope, it's not. Okay, hold on. I have to shrink it down. Try this again. There we go. Okay, now I think I can make it bigger. Bye. So funny. A lot of times when I do these Zooms, Lane will be like, everybody can see all of your screens. I'm like, oh, that's true. There we go. So if you might have noticed, they've actually changed around the placement of the tab. So be very careful. If you're normally used to clicking on transaction desk or express forms, they've moved. Express forms used to be over here. My MLS used to be over here. So just notice they've made a few changes around through here. So now for training purposes, I always use express forms. I recommend that you never use express forms for actually doing your contract, because if you do that and you save it on your computer, I can't see it as your designated broker. I can see everything in transaction desk, which is my happy place. So that if you ever need me to put eyes on something and you can't email it to me, say, Genine, can you go in my transaction desk and I can look at it from there? Okay, so let's just talk about our purchase and sale agreements. You've got options here when you're searching, just like any search tool. You can type in the word purchase and sale. You can type in the actual number. Remember, we've got multiple numbers for purchase and sale agreements. You can type in part of it and see what shows up. You've got multifamily, you've got residential, you've got manufactured on leased land. These are going to be your mobile home parks. You've got your vacant land, and you have your condominium. Now, the purchase sale agreement didn't change too much except for the email I sent out this morning that added a full-on paragraph at the end was the biggest thing that they changed. If you have not pulled any of the red line stuff, I think it's still available if you want to have it. Even though I know these forms inside and out, I still took the 3-hour course with the Northwest MLS with the attorney, Jeannie. And then I consistently take forms classes whenever I can, because I think it's hugely important to know when things have changed so that you are well informed. Like when I had just been talking about my friend buying a house in Eastern Washington, the broker wrote up all the stuff. She sent it to me to review because her DB didn't know how to help her. So why not have somebody who's not even in their office help them? And I'm like, you're using old forms, right? I mean, we've had new forms since the 24th of February, everybody. If you've got an old form, you're going to get pushback from our reviewing broker. And depending on when you used it and when you started the transaction, I might be able to go in and decide if I can push it through or not. So you may need to have my help, and that's totally fine. I'm happy to help in any way that I can. Okay, so here is the purchase sale agreement, and this is just the very simple residential purchase and sale agreement. Okay, not doing anything fancy here. This particular page, nothing changed except for them adding in new copyright information and utilizing and changing this date here to the February. So this page itself did not actually change. I will point out, as I always will point out, line 17, A and B. Okay. A equals the statutory obligation for disclosure. So this is where the seller is disclosing to your buyer, I am willing to pay So you don't have to pay, buyer. I'm willing to pay X number of dollars or percentage. Your obligation on behalf of your buyer is to also disclose how much your buyer is asking the seller to pay on behalf of them so they don't have to pay it. And that number needs to be either a number or percentage, whatever is on your buyer representation agreement, your BBSA, your Form 41. If you put a 3 here and your BBSA says 2, you're not going to get paid. Okay? So knowing that you need to put a number, they do not need to match. This needs to match the number that's on your BBSA, period, end of story. We will talk about this line here, addendum for buyer credit, which is Form 41C, and that's a seller obligation, okay? So on this page, nothing really has changed except for changing some dates, okay, at the top. Now, if you go to page 2, paragraph B, there was some changes in regards to instructions to the closing agent. Disperse, let's see, I here, they changed this by adding I, and then they added the 2 I's, and that's all that they've changed on this page. So they're just defining some additional terms or spreading it out a little bit differently. That was all that was changed on page 2 of the purchase sale agreement. Now, there was nothing changed on this page, which is page 3. Page 4, again, nothing was changed. And page 5, we had some small changes in regards to brokerage firm compensation, paragraph U. There was language added. I have to put my glasses on so I can actually see my screen now. Where it says 17B, they added, let's see here. Not this section. It would be this section here. Amounts described as a percentage in specific terms. So that's what they added, was they're just letting you know that you don't have to specify unless your BBSA is in a dollar figure versus a percentage, okay? So again, it's going to just define whatever the seller is offering in their percentage or a dollar figure. Again, you do not need to write a dollar figure if your BBSA is in percentages, and that's for line 17B for compensation. And then, of course, builder may have a base price clause in their builder addendums to watch for as well. So always watch for that. Like if your client's buying new construction and a builder addendum is written in as to be attached, and they say that your compensation is based on a base price of the house before upgrades. So if the house is $500,000 and your client adds in $150,000 and wraps it into the purchase price, the builder in their addendum may say it is going to be based on that original $500,000. So watch for that. And if your client is required to pay you more because that's what your BBSA says, great. Please note that if your buyer is going to pay any difference, there's an addendum for that, a disclosure for that in the BKCO hub, as well as the transaction desk templates. Okay, you have to go into templates and pull it out, and don't fill it out in templates, but pull it out and then add it to your transaction desk. And that is if your client is going to pay the difference. The example would be seller is paying 2%, buyer has signed a BBSA at 3%, and the seller, you've asked the seller to pay the 3%, and seller says no. So then you're gonna say, okay, buyer, you're on the hook for 1%. Okay, then there you use that disclosure, so it discloses to the lender and it discloses to escrow. There's an additional funds coming for your compensation at escrow. Now, let's say seller's offering 2, your BBSA says 3. You and your buyer have a conversation before mutual acceptance. Buyer's like, do I have to pay you that? And again, I'm going to leave that up to you. That's completely your call, but you must change your BBSA, your buyer broker service agreement, Form 41, prior to mutual acceptance. If not, I am legally told you cannot get paid. So make sure you do that first. You can do that either on the face of your BBSA, which I don't recommend. I recommend you use an addendum, which is 41A, the addendum to your buyer broker service agreement, the addendum to your BBSA, and you change it for this specific address only. And then that way, if this offer doesn't go through, then you only have shifted your compensation based on what you and your buyer agreed upon for this specific property. Okay, our biggest changes came to page 6. First off, which 22D we're not going to look at today, but 22D, which is the optional clause addendum, page 1, paragraph 1, used to have language in regards to brokers make no representation on such and such and such. They took that off of that form and they added in right here at 227, 227 down to where it says footage, lot size, footage right here, and encroachments, okay? So they've shifted that up to the end of here at buyer satisfaction, okay? So right here is the end, and here is the beginning, okay? So 227 down to 231, satisfaction, okay? So they've shifted that whole paragraph to right here. That's it. That way, you don't have to worry about checking that box. It's now automatically part of our boilerplate. Is 22D still a viable form to use? Yes, and we will talk about that when we talk about 22D in the future. The next biggest paragraph will be down to paragraph Z. This whole paragraph was added. This is all brand new. This is based on money laundering. I sent out an email today. I sent out a really good flow chart. If you're a buyer, this is a buyer issue, not a seller issue. This is to make sure that buyers are not laundering money through houses. And so the government has stepped in and said, yada, yada, yada. So this will be based on a corporate entity as a buyer. An example would be an LLC, a trust, a trustee, not a bankruptcy trustee, but a trust. It could be a corporation, and they are paying cash or using a non-traditional financing source. So the example would be your buyer is an LLC buying a property because they buy all of their properties in an LLC and they're going to flip it. So they're now going to be one, a corporate entity, and two, they're using hard money loans because they want to flip it fast, get rid of it. They can't get this loan traditionally, so they're going to use their favorite pal down the street, Mr. Hard Money. This will trigger the fact that now, who is ever in that LLC, everybody in the LLC will need to disclose all of their financial situations to make sure that the government says, great, I can see you are not doing any money laundering. So this is for our buyers. This is something to talk about. If you have a closing between now and the future, and your client is a corporate entity paying cash or hard money loan, non-traditional financing, that person is going to get scrutinized. It could, not always, it could need an extension of closing. So make sure that everybody's very patient with this situation. This happened on March 1st. And so a lot of transactions were started before even the forms changed, as well as the fact that it was closing after March 1st. Buyer is responsible for any of the costs. It's not triggered on all transactions, just know that. It is the newest provision in this form and is a disclosure and may affect the purchase sale agreement like we've talked about. So,
Janine, do you have a sense of what the cost will be?
Do I have a sense of what the cost will be? I have no idea. That is a great question for your favorite escrow closer.
They say it. Okay.
It will not be based on conventional financing. It will be based on non-traditional. That was a question in the chat room. It'll be based on non-traditional financing. Any other questions on paragraph Z, which is called FinCEN? Again, I sent an email out to all three firms this morning. If you didn't get it, please send me an email, and then we're making sure that you are getting our emails, and especially mine. I will only send out emails that I really need you to pay attention to. Very rarely will I send out fluff because I want to make sure that you are paying attention to some of these things that do change. Does this apply if it's their own cash? Absolutely. This applies if it's their own cash. So a cash transaction, non-traditional financing. If, and again, to answer your question, Trevor, if they are a corporate entity, if it is Genine and Scott Wood, by the way, this is a training class, it's not about real people. If it is two people buying as, a married couple, traditional, I'm paying with cash, I'm not a corporate entity, I will more than likely not have an issue with this. Okay, so again, that flow chart will show you exactly who will be required to follow these procedures. For how long will it take? I think it's going to be a matter of how much the investigation has to go through to determine to make sure that there is no money laundering. I don't know how long it would actually take for all of that to happen. So again, we need both sides to be patient. I would highly recommend that if you used a per sale agreement prior to the forms changing February 24th, you might want to get an addendum turned around that spells out, and I would physically just write this into a 34 and put that as part of the purchase and sale agreement and have all parties sign. 34, and you would add paragraph Z. If you have a per sale agreement that was started before the 24th of February and closing after March 1st. And it is part of this if you have a cash person or a corporate entity. Any other questions on that? Okay, let's go on to 41C. I'm going to go back up here to the top really quick. Now, 41C is going to be used when you check this box here, addendum for buyer credit. And the reason you're going to check that box is because your buyer broker service agreement, which you're going to put the number here, says 3. No, excuse me. It says 1.5. And the seller has disclosed to the buyer, I am going to pay your broker as the seller buyer for on behalf of your buyer broker, I'm going to pay them 2.5. We have a 1% difference. This means that in the only time you use this box, if A is higher than B. If it's reversed, you're just asking the seller to pay more on behalf of your buyer. You will not utilize 41C. So 41C and why this is important. So there are many times where I hear that you guys are giving, I'm going to use the word rebate to your client, your buyer client. Maybe your BBSA matches and says 2.5. And now you've decided to give money to your client. That is going to be on a form 34. You will not utilize form 41C. Okay? Because 41C is only if A is higher than B. That's the only reason you use 41C. I just have to stress this many, many times. If that's the case, then you're going to check this box. And this is why this is important. Because let's say I've decided to rebate Sally Sue my commission of 1% because maybe my BBSA says 2.5. And Sally Sue, says, Genine, I bought 20 homes from you. Can I have a percent back? Well, Sally Sue, absolutely. I mean, you've actually bought my last house for me in cash. So sure, why not? Now I have to write an addendum. And now I am financially responsible for the tax on the commission I will receive. So if the document says I'm getting 2.5, but I decide to give a percent to my buyer, our office has to report to the DOR that I'm actually being paid 2.5, even though I'm only getting 1.5. So let's go back to why we like 41C. So 1.5 is what my BBSA says. And I knew that I was always going to charge her less rather than rebate. I was just going to charge her less. And I'm going to let the seller give her a credit because then the seller is on the hook for that taxation. So if you look at Form 41C, you'll look at the language that says addendum for buyer credit. Yes, that's true. Let's bring this a little bigger. Here we go. Seller credit to buyer. Not me as a broker. The seller is now crediting the buyer the difference. You would check this box, and you can simply check this box, the difference, or maybe it is a certain percentage instead, so you can break it down differently if you want. Maybe it's 0.5. Whatever you feel is the easiest way to do this based on your outcome. But normally, if there is that difference, you're going to absolutely check this box that the difference between the amount of the seller's offer of buyer brokerage firm's compensation and the amount to be paid by the seller as set forth in the first page of the agreement. So then you're going to also want to follow this. Seller's credit to buyer shall be credited to the buyer's obligations if the buyer is obtaining a loan or loans of the purchase of the property. The credit to the buyer set forth from the seller, subject to, bless you, lender's approval. Any amount not approved by the buyer's lender shall be applied towards a reduction in purchase price, or is it going to get to stay in the seller's pocket? Now, in a multiple offer situation, you may not even check this box. You may come straight down here to make the buyer's offer look more appeasing. She's like, I don't want the credit. I want the seller to see that I'm not going to take the extra money. I want them to keep it in hopes that my offer would look better. So knowing what that also means. Then they added additional language. There may be other credits in this agreement, which is very nice that they've spelled this out, because I can talk about this till I'm blue in the face and still some people just don't grasp it. Being in the business for 1 year versus 30 years. So it's always been this way. And so it's the way I've learned and the way that I've always taught for decades. If you're already asking the seller to pay the buyer's closing costs in full, lender has told you under no other circumstances, the seller can only, well, any party in the transaction can only pay a maximum of 3% of the purchase price towards the buyer's allowable closing costs. That is on page 2 of the financing form 22A on the first paragraph of page 2. If you've used all 3% and you still have a 1% issue here, discrepancy in compensation, you don't get it, buyer broker. You cannot take it unless you've amended your BBSA and changed it from 1.5 to 2.5. But the buyer may want it applied towards a reduction in their purchase price. So you would check the top box, the difference between the amounts, and then you would check applies as a reduction in the purchase price. The other opportunity for a buyer to get concessions would be their inspection request. So they have now requested a credit in lieu of repairs because the seller tried to make this really pretty bathroom and it's kind of a piece of so we're going to fix it later because there's some plumbing issues, but I don't want the seller to fix it because they already screwed it up. So I want to do it after closing. So I want them to give me $5,000. Well, sorry, they can't get $5,000 because they're maxed out based on their 22A financing, paragraph 1, page 2. So making sure that if you're doing all of this now, the buyer understands when the lender says you get a maximum amount of contributions from the seller towards your closing costs, that is the maximum amount. Now, could there be other concessions paid for that you might have to help the lender describe to you? Absolutely. If you're in a community with an HOA, condominium or housing, can we pay umpteen months, umpteen years from the seller to pay the HOA for them? That's an option. What about reducing their percentage for their interest rate? That's an option. So making sure that you're going through every possible example. In the West Seattle office, we had I want to say it was probably before the end of the year, one of the brokers here representing the buyer. BECU said absolutely they can get 10%. I'm like, I've never heard of that before. And then lo and behold, we're getting closer to closing. Oh, you know what? Wait, they can't get 10%. It's already written in and now the buyer is expecting it. But you'll also need to, when you're in your buyer consultations, pull these forms out, go over them in detail with your client so they understand before they sign something. I know that I'm going to say probably 99% of the people that sign our firm's disclosure packets never physically read them or even really look at it. They click and sign on their phone and it's 56 pages. They never go back and look at it. I actually know what it all says. You should too. But I'm sure that's not probably the case. But if you go through this with them at the consultation, when they do have the time to sign this, and they might be signing from their phone, they might pull over on the side of the road at the CVS and sign their documents, but at least they'll know what they're signing because you went over it in the hour and a half consultation you had before they actually got in your car to go look at houses. So again, this is a very good tax savings for you if you're automatically going to make sure that your client is getting a credit from you. Let's put it back on the seller and have the seller pay that credit instead. You'll know if you're going to rebate the minute you sign your BBSA. And might as well make your BBSA match whatever it is you're physically going to charge your buyer if the seller's not going to pay in commissions. That's our job. Any questions on 41C? That was pretty easy. Our next form that we're going to go over is going to be 22B. This is the one that gets most people. This is if your client has to sell their house and get the proceeds from that house in order to buy the next house. It could be that the full amount of the purchase price of the new house they want to buy will be covered by the proceeds of the sale of their existing current house that they live in. It could be that you need a 22B and a financing addendum if they need to get financing. It could be that you will utilize Form 22B, 22A, and 22EF. What you will not use together will be 22B and 22Q. You will either use Q or you will either use B. If you start with B, you're still not going to end with 22Q. 22Q states, I have my house on the market 2 months ago. I have a buyer under contract on my house. I now make an offer on your house seller, and I'm already under contract. So I am not a contingent offer. I don't have to put my house on the market and get a buyer. I already have a buyer for it, and I'm a pending sale. You will go either into pending inspection or pending, but you will not go into a contingent status seller because I'm utilizing a 22Q pending sale. So you'll never, again, I'm going to restate it. You will never use 22B and 22Q in the same transaction on the same property. Again, you might need financing, so you will need a 22A as well. 22B, 22EF, evidence of funds you might need if the buyer has to disclose other contingent funds that are outside of the financing and outside of the home sale contingency. An example might be they're getting a gift from grandma. Okay, that might be why you use a 22EF. If they're getting a grant as part of their loan, that will not be on 22EF. That will only be on 22A. Okay, so there are nuances on how you use these forms together. And if you're ever confused, please call me before you write because I'm more than happy to help. Okay. Okay, contingent. This is on contingent sale of buyers selling their existing property at this address. That hasn't changed. What has changed is, let me see if I can get the biggest change is purchase price. Excuse me, list price of that property. Let me grab something here really quick. Okay, there we go. So this has not changed. Paragraph A has added from here, if selected, the list price of the buyer's property shall not exceed whatever the number is here. Buyer brokers, leave this blank. Buyer brokers, leave this blank. Now let's switch hats. Listing broker, fill it in. You should never be in a situation, unless it's out of state, especially, where you have no idea what the buyer is going to list their current property at. You should always do a market analysis on the property before your seller accepts a 22B buyer offer. If it's out of state, you call somebody in that state that is not the listing broker of the house to be listed. You call somebody else to do a impartial, what I would call a BPO or a broker price opinion. Should you pay for that? Probably it makes them more motivated to do their job. But this way, then you have an idea of what number should be there. Listing broker, fill this in. Buyer broker, do not fill this in. Okay. So this means that at no time, like let's say the buyer wants to list at 500, it's only worth 400,000. I would explain to my seller why this would be a bad job taking this offer. So let's fill this in and say you can't go any higher than 400,000. It's not worth 500,000. So that is the biggest change that was made on this form. The other changes were very minor where they did paragraph 5 and they simply changed a word that buyer may not change. It used to be extend the closing date. Those are the changes. Now I want to go over a little bit of the nuances on this form for you to pay attention to, especially if you are the buyer broker. Number 1, you make an offer for your buyer and you list the buyer's property within 5 business days of mutual acceptance. If you do not list, your buyer has waived this contingency, which waives every single contingency in their offer. Financing, inspection, you name it, gone. Do not overlook this. Pausing for question. If FERPTA applies, will it trigger this? That might have been an older question. I'm not sure. So, Michael, I'm not quite sure if that was for the old question.
Yes, it was.
Okay. FERPTA has to do with the seller. Vincent has to do with the buyer.
Okay.
They're different. What would happen when writing an offer that is contingent if you fill in the max amount for the list price of the contingent property? What would happen? Nothing. The problem is your client cannot go below that at any given time. That is what you can list at. So I'm sorry, couldn't go above it. You can't, yeah. So if you list it for whatever, if you put the number here, you're listing it at 500,000, you put 500,000 here, seller signs it, no harm, no foul. You can always go down. You can just never go past the 500,000. So paying attention to your 5-day rule. Yes, it might strengthen the offer, but if you're not in a multiple offer situation, I'm not going to give away the farm. I'm going to let, it's really going to depend upon what your buyer wants to do. Number one, remember, we are going to coach people in our transaction, but we're not making decisions for them. So you need to tell them the pros and the cons of this particular blank and let them make a decision. And if they really want the property, then you strongly say your offer will look stronger if we just give them this number now. So many people are not paying attention to this form. They have no idea about this change. So that's part of it. If buyer has not sold the property or given notice waiving this contingency by the end of the contingency period, which by the way is a 45-day default window. So if you want it shorter or longer, fill in how many days here. Never do hours, by the way. Then this agreement shall terminate. Earnest money is given back to the buyer. So when the seller's consent is required of the contingent property. So we are in a contingent status with seller as a 22B buyer, and we're 10 days into it. 10 days into it, we get an offer on our house that's listed at the top of this form. But the buyer has to also be a 22B buyer in order to buy my house or the next house. You have to have seller's written consent. Okay, so making sure that seller's written consent will be on form 90L or a similar form, if depending on maybe if they have an internal form or whatnot. But let's say we're 10 days into it, I get an offer on my house, and now I'm going to notify the seller, yes, I have an offer on my house. The buyer on my house is a 22Q buyer, means their house is pending, not contingent. You do not need seller's consent. Okay, 22B, you need seller consent. 22Q, you do not need seller consent. Now, seller, you got to be very careful with some of this because here's the next part. Let's say we are 10 days into it. I get an offer on my house. And they're going along just fine. Well, let's say they get an offer on their house, which they didn't tell us they needed to sell it, which they could be in default at this point. And that's a 22B buyer on that end. 22B buyer can go along and along and along. So if you seller agree for a 22B buyer to accept another 22B buyer, that 22B consent stops there. If the buyer behind that is also a 22B buyer, you have no control over that. You can say nothing about it. And so remember, when we're doing all of this, depending how things sell, somebody could become homeless if somebody gets bumped. So making sure that we are very familiar with this form and what that could mean. And again, when in doubt, call me if you have any questions. Does the buyer need to make loan application before selling the house within 5 days after mutual acceptance, or when they get an offer on their house? I think any buyer broker, no matter where you're in this situation, I think you're going to want to have it sooner than later, just so you make sure that they don't get denied financing and then the whole thing falls apart. And they will have the protection of 22B no matter what until they waive it or satisfy it. So once they do satisfy it, the bumpability goes away. So once they tell you, I've got an offer on my house, you change from contingent listing broker to pending or PI, wherever you are in the process. It is now a non-bumpable buyer. But the property can remain on the market until the buyer has proven they have a viable buyer that you don't have to consent to. And then you become then non-contingent. Now, let me go back a second for the other reason a seller might need to consent. So our 22B buyer is getting an offer 10 days into the process, and the offer is closing 29 days from today. That would violate this whole part if the seller has not given written consent. Or they're closing 46 days. Again, they have violated, waived everything if they did not have seller consent. Remember that when you write a purchase and sale agreement with a 22B buyer, you are not going to have a closing date on the front page of your purchase and sale agreement. On the closing date, you're going to write C22B, okay? Because the property has, or excuse me, 22B has an automatic closing date. So here it is. Contingency satisfied. Buyer shall give notice to seller within 2 days of entering into a purchase and sale agreement to sell buyer's property. We're 10 days into it. We get an offer. It's not contingent. It's closing between 30 and 45 days. We need no seller consent. Buyer's notice shall include a copy, complete copy of the purchase sale agreement for the sale of the buyer's property. The sale of the property shall close 3 days after the closing of the sale of the 22B buyer's property. Okay. Now, people, pay attention to the fact that we now have a 3-day window. We're going to close one property. The next property does not close for 3 days. Where is our 22B buyer going to live? That 22B buyer needs a rent back in their property, unless it's vacant and it didn't matter, whatever the situation is. But if they're living there, they're going to have a really hard time closing on the other property in 3 days, because that's when it's supposed to close, and being able to move. So pay attention to where they're living and if you need a rent back. And when it says here that you need a complete copy to accompany the notice, remember that whatever that is, that also needs to go into command. Don't think you just need to serve notice and give the complete copy to the seller side and just give me the notice and command. Give me the whole package. Let's say you are 10 days into the purchase and sale agreement and 22B buyer has not gotten an offer yet. But now the seller has served the buyer with a bump notice. I have another buyer that wants to buy the house. If you can't satisfy your contingency within X number of days based on the bump. The bump time period default is 5 business days. So most listing brokers will shorten that to 1 to 2 to 3. Remember, anything under 5 days is business days. So you can't land on the weekends. You can't land on the holidays. So whatever the number is here, you bump the first buyer. Buyer really wants the property. They're on their last day of the bump period. They have 2 more hours. So it's now 7 p.m. on the last bump day. And they're like, shoot, I want this house so bad. Mom and Dad, will you just give us the money? Sure, we'll give you the money. So then the buyer decides to waive their contingency. Again, by waiving the contingency, you waive every single contingency in the offer, whether you have defaulted on this particular form or not. Once you waive everything. Financing, appraisal, all of it. So making sure, unless of course your 22A says it does not waive if I waive financing, your appraisal will stay intact, just depends. But just know that you have that risk to your buyer. And then all of a sudden, mom and dad say, you know what? We decided to go to Europe for 4 months. We're not going to give you that money. So you got to be very careful with parents giving money and grandparents, especially if they get into fights, which does happen. There is a clause that if it's new construction and getting the certificate of occupancy, it has another default there for pure safety. There is a very simple version of 22B. I like to keep it simple when Annie Fitzsimmons can talk about it for 3 hours straight, and I can do it in less than 30 seconds. Any questions on 22B?
So in that waiver.
In the waiver?
So if the parents give the money and they're doing that, then in order to not waive, would you then do a whole new contract?
No, you would not do a whole new contract because there isn't an option for that, because right now this buyer is getting bumped.
Right.
And this means that there's a buyer 2 in second position as in second position, which again, listing brokers make sure you do not get backup buyer and second buyer forms confused. Okay. Here's the problem with that. And that's a very good question. So the question was, well, they're getting a gift from mom and dad. Wouldn't we just, rewrite the contract to satisfy this and not get the risk of having to waive or getting bumped? Listing brokers won't go for that, and they'll tell their sellers why. Number one, we've now heard there's a gift coming. Lender, does the lender know about the gift yet? Is the money cured in their bank account? Is the lender going to allow the gift to happen? So it's really going to depend on the rest of the addendums in the contract. If there's financing, there's a huge risk to a seller saying, let's scrap potentially the one that's bumping you, and we'll go with buyer number one. It's too much of a risk. And a lot of times you're going to have to put on both hats when you're thinking this through. Do I have my buyer hat on or do I have my seller hat on in order to help and coach our clients through these? Now you're gonna sell properties in many areas. And the one example I've given earlier where my client is selling a property in Magnolia, a duplex, so very viable property to sell. Plus it's a giant lot. High likelihood they could condominiumize the backyard and all the things. However, they're buying in Pullman, Washington, not a very fast market. The house is probably also $100,000 overpriced that they want to buy. So they're, but once they sell their duplex, they don't need financing. So they're just buying straight cash to the new property. However, they're going on vacation and Pullman is 4.5 hours away. So on this one, you might, as a buyer broker, you might want to say that they're not going to be able to list their property for 25 days, depending on the situation. Will a seller go for this? Maybe, maybe not. You've got to make sure that, and whoever's on the other side, like I'm not the broker there in Pullman, Washington. It is somebody else that I'm having to help her fumble her way through it because her broker doesn't know what to do. And the listing broker, we're not quite sure he knows what to do or he was even going to recognize this. The saving grace, and this is why you want to ask as many questions, get as many missing pieces of any puzzle that you can. The seller just rented out the property yesterday. Doesn't have an offer on the property yet, doesn't have mutual acceptance, so they can do whatever they want. So it might behoove them to take somebody that needs to list in 10 days versus 5 or 25 days instead of 10 or whatever the situation is. So find out pieces before you start putting this together. When we're here in a little tight market in Seattle, it's going to be way different. So again, please feel free to reach out. I'm happy to help with any of these blanks that you don't understand or walking you through what all of this means. I'm right now talking to a broker every day through all of our market centers that will have a question on 22B that they're currently in a transaction, whether the listing side or the buyer side. Any questions on 22B, home sale contingency? Okay. Last form. Oh, yes.
Yeah, maybe it's not applicable to the area where I just wrote an offer on the other day, yesterday, and there was 11 other offers. Um, so I guess my question is in King County, specifically the Seattle market, how often are people even putting contingencies on in? Is I would say a very small percentage, or is that not the case?
It's going to depend on the property. Every property is different. If it's a multiple offer situation, you're not going to get away with a 22B, more than likely. More than likely. Have I seen it happen before? Sure. But it really depends. If someone's overpriced the property, classic time to use something like this. So it just depends. And what if that works for you? You got to remember it has to work for your seller. Well, what is the seller's next step? Like where is this money coming or going to when they're all done?
Thank you.
You're welcome. So I'm also answering questions online. Yes, this is recorded. It will be in the BKCO Hub under the training tab by the end of tomorrow. Okay, last form is 22D optional clause addendum. Again, small changes. The biggest one is they removed paragraph 1 and left us with now title insurance as paragraph 1. So they took away the broker's responsibility about sizes, encroachments, and such, and put that into the boilerplate where it should have always been, quite frankly, into the purchase and sale agreement on all of those forms. You probably will still never check a box here. There's no reason to. You have to, okay, somebody is messing with my form. I can see you writing on it. It happens from time to time. I don't know how people can get into your Zoom and just do that. It's funny. Okay, standard. Okay, there's 3 levels of policies. If you use your last 3 fingers, your pinky, your ring, and your middle, that tells you the size of the policy your client's going to get. You're automatically going to get the middle of the road, the ring finger. That is the policy the buyer is going to get paid for by the seller. If you check this box, you're downgrading the policy. If you check this box, you're upgrading the policy. And by upgrading, that will include, that's okay, that will include a survey which your client will more than likely not need. Like neither of these boxes should be checked on a condominium purchase sale agreement by example, okay? Seller cleaning means broom swept, you guys. If you want professional cleaning done, either pay for it as a closing gift or add it into the purchase sale agreement and be very specific on the company, the time when it's going to be done, and all the likes. Don't ever let a professional cleaning ever get a buyer and a seller into a fight. At the end of the day, if I put it in the contract and the seller didn't do it, I'm going to talk to the listing agent. Listing agent better do the right thing and get it cleaned themselves. But at the end of the day, if they don't, I will at least do it. It's a few $100s versus lawsuits. There's no reason to have a lawsuit over a cleaning. Most of the time, the judge will probably laugh at everybody and send you on your merry little way. Personal property. This could be a catch-22. What is considered personal property and left behind? Now, let's say we'll use my backyard as an example. For barbecues, I've got an egg and I have a Blackstone. A lot of men like those two items. Like I could care less, but again, it's my husband's stuff. And I leave those behind because they didn't fit in the truck. And now it's 9:01 p.m. and the buyers have access to the property. Those are personal items, but because they're there after possession, they get to keep them. But let's say I feel my personal property in my garage are all of these little wood chips that my husband uses as shims and widgets and all these little things. I don't want to take them because I have never seen a need for them, but my husband loves them, but he didn't notice I left them behind. I consider that personal property. The buyer might look at that and think, this is pure junk, which is how I look at it. So again, it can be a catch-22. So be careful when you're checking that box, what is really considered personal property. My favorite examples have been years past, because I've been doing this for 30 years. Vintage Mercedes left in the garage. Well, we had a title issue with that one. Just, yeah. Diamond ring found in a vent.
Oh, wow.
So those are the examples you want, not the wood chips in the garage or the wood pile on the side of the house that used to go to the external little wrought iron fire pit that has rotted through. That's personal property. And I've decided to leave it because I don't want it anymore. Again, that's personal property. It's rotted and gross. So again, one person's treasure might be somebody else's trash. So again, that's like a catch-22. Leased items. Don't check this box because the boilerplate of the purchase sale agreement already takes care of the fact that the seller has to pay it off. Now, listing broker, pay attention to this. Some things can't be paid off. So you may need to check this as a listing broker because buyer broker is smart enough not to check it. You need to be smart enough to put it back in because the propane company will not let you buy the tank outright. So the buyer is going to have to lease it back. And then they updated the home warranty with some additional information on who's the provider that was always there. Seller shall pay X unless otherwise drafted here. Maybe you're paying it, maybe the listing broker's paying it. So they cleaned up some of the language there, but really the biggest change was removing paragraph 1 and moving it to the purchase and sale agreement. And these other items I talked about are just some little housekeeping items I like to talk about on a regular basis. So there are your updated forms for this week. There's a few more next week. Any questions? Well, that was pretty easy. I appreciate you all for joining. This will be recorded, BKCO Hub. Watch for it by the end of tomorrow. If you do have questions and they're a little bit more specific, you didn't want to ask it online, send me a text, send me a phone call. I'm happy to help answer in any way that I can. Thank you for joining and enjoy. Oh, I got some chats. Hold on. They're probably saying thank you. That's what a lot of them do. Thank you. You're welcome. Thank you. Thank you. Thank you. Very welcome. Love to you all. I was doing this earlier. Let's see if we can get it to work. I can't get it to work. There it goes. Yay. All right, guys. Also, since you're on here today, Thursday, 9:30 a.m. to 12:30 p.m. If you want to audit the Annie Fitzsimmons course tomorrow in the Kirkland office live, please come join us. There is material she does give me. If you join me in the morning, I will show you how to get the materials, but you have to be live in Kirkland only. So,
Genine, what time is that? From
it starts at
9:30?
9:30 tomorrow morning in the training room.
Okay, thank you.
You're welcome. Take care, guys. Bye.